Can a robot, can an AI, can an LLM own something? As of right now, the way that both the recent Italian law and the American courts have currently held it, and look, this could change next week because the space is moving fast. The monkey doesn't get to own the picture, and the robot doesn't get to own your stuff. If a human significantly engaged with and created the thing, what happens?
Samantha Bradshaw is an intellectual property and trademark lawyer and is the founder of InLine Legal. So nice to have you on the podcast. Tell us, what is your story and what made you want to become a lawyer?
I want to become a lawyer. I think I was just a precocious child and decided I wanted to argue for a living. As far as winding up, at least in this area of law, though, I've bounced around a bit. When I was in high school, I was already working in law firms, and I was working in criminal defense in the United States and got very dissatisfied with the system. Like, I tried to use the system to right the wrongs, and the system failed miserably. And I know, there's balance in staying in the system to try to change it from within. And I was not at a place where I was going to be helpful on that fight. So I left the US and started working in international corporate law, helping small businesses expand outside of their countries, expand outside of their regions, and really seeing the importance of those businesses where, when there's a good quarter, the owner gets to send their kid to the nice summer camp instead of just, the affordable one. That was such a meaningful thing to see, of like, oh, but them making more money allows them to have better choices in their lives, create better situations for their families, for their communities. That feels a lot more aligned than trying to fight a criminal justice system from the inside. And I did that for a couple years, came back to the States for a little bit from Lebanon, and decided to open my own firm, trying to help those same business owners. And we were acting as kind of like a part-time in-house counsel for small businesses, which was wonderful. But something I kept seeing again and again was there was such a lack of knowledge around how to use legal protections to expand, how to use legal protections to trade, working hours for money, to I have created a system, I have created a business, I have created something that somebody else can run, and we can all work normal hours instead of crazy entrepreneur startup hours, at least after a few years. And that lack of knowledge about what ownership and what those legal protections were and could mean and how to defend them really made me transition this firm into a trademark and copyright firm. So we still have the same premise that, this firm exists to help small business owners, men, people of color, immigrants get their legal in line for their business. So we're InLine Legal. And now it went from more of a compliance of like, okay, we're going to help you check the boxes, we're going to help you get this right, to no, now we're helping you strategize from the beginning, from day one, of what is it that you can create and put in the world that's a framework, a model, a brand, that power that comes with trademark and copyright, and how to create extra revenue streams from it. But getting you that foundation point of knowing what it is that you're creating, knowing how trademark and copyright apply to each brand, and then seeing how we can create those opportunities for you to expand, license, be able to send your kid to the nice summer camp.
You're 100% virtual intellectual property law firm. How does that work, and how do you get what kind of clients do you have, and what kind of clients do you help?
So we were virtual before the pandemic, which was a bit of an uphill battle. One of the smaller silver linings to the pandemic is the world realized that things could be done online, and not just things like, not just, silly dance videos on TikTok, which was still Musically at the time, by the way, but that professional services, that legal services, financial services could be done online. You didn't need to drive to a physical location, fight to get a parking spot, wait for the secretary to let you in, drink some cold coffee that's been sitting in the conference room since, 7:30 in the morning, and then have the 15-minute conversation you needed to have with the professional. You could jump on a Zoom call. And fortunately, not just in the service providing aspect of it, but court systems around the world started accelerating their plans to be more virtual first. In the United States, there's actually an entire copyright court, like a small claims court, that is entirely virtual. And it was created in the wake of 2020. And we're seeing that globally. Brazil has digitalized everything to the point that the people in the physical locations are actually not as helpful as the online things are anymore. In the EU, we're seeing massive pushes for digitalization as well. So it wasn't hard for the service provider to start operating in this space, especially when the governments are playing ball with us. But that was super helpful. And then as far as clients, again, back to the whole virtual thing, what's been wonderfully helpful is that because of the virtual aspect of things, we can have these longer conversations, these strategy conversations with both small business owners in the United States and more advanced business owners outside of the US that are trying to bring their products, their services into the US market. Because despite all of the nonsense in the world, the US still, as a business, if you're trying to expand, is still one of the largest markets with a significant disposable income, despite all the inflation that's happening in the US right now. So if you're selling something, it's still really tempting to try to get into that market. And so we have started working with a lot of folks who are doing exactly that, trying to enter the US market. And we make sure, because the US trademark system is wildly different than, frankly, most of the world. A lot of the world has the idea that if you're the first to file this paperwork, then you are by default the first one to get the rights to use the brand. And in the US, that's not the case. We've seen folks come in and somebody in the US is already operating under that brand name, and the non-US company will come in and be like, okay, we filed. And it will just raise red flags to the US company that's already operating under that brand name. And then they wind up with, a multi 5-figure legal battle that they didn't know they were ever getting into. And now product is stuck waiting at the ports, or they've hired people and hired space to deliver whatever the service is in the United States. And they're all on a freeze until they can figure out the brand name issue. So we're helping those non-US companies make sure that it's available, their brand name in the US, before they ever even enter, and then getting them through that trademark process so they can, for physical products, copycats at customs and counterfeits at customs. So they can know that they're entering without pissing off an American company and starting that 5-figure legal battle. And then our small businesses in the US, I don't know, we love them. We love helping folks create those systems where they can earn enough money for them, their teams, their families, their community, where they can send their kids to the nice summer camp. That's all.
Where do your clients come from? Primarily, is it EU, South America? Basically, if they're from the outside US and wanting to enter the US.
Yeah, so the bulk of our clients are American companies. I'd say as of right now, our non-American clients are overwhelmingly Brazilian or operating from the Gulf. That being said, they might be Gulf companies, but the founders are normally not Gulf citizens. We're normally talking Lebanese, Syrian, Egyptian, Jordanian. There's a lot of immigration from the Levant and the MENA region over into the Gulf and starting companies there because the UAE has been, frankly, very welcoming to businesses, foreign founded or not.
What kind of a pain point are you solving?
Yeah, absolutely. So apart from, the systems of most other countries in the world, because they operate on a civil law system, whereas the Americans operate on common law. If you don't want to go into a large history lesson, this is basically the difference between whether you were colonized by the French or the English. If you were colonized by the French, all of your laws are written down. If you were colonized by the Americans, it's all decided by the judges. Most systems have become a merger of the two, but mostly the civil law systems, those colonized by the French or mimicking the French legal models, have set up this idea that the first person to submit the paperwork to the government are the ones that get to own the brand. In America, it's a bit different. It's the first ones to be using it publicly. We give a lot of deference once you have a registration for a trademark, but submitting the application to get the registration does not create the same level of protection that it does outside of the United States. And a lot of business owners don't realize this. And of course, as CEOs or acquisition experts, their idea is to look for new markets, new places they can go and start executing on how to get there. Trademark doesn't tend to be top of the SWOT list when they're looking at it. And I fully understand why we're not on that. But the problem is when people forget about us, when people forget about this issue, it can stop the entire process. So, something that I did quite a lot working back in Lebanon was literally translating these different ideas of how different systems work from one person who understood one system to the person who understood the other system. We can use the same words, but that doesn't mean you understand the difference in the systems, right? Because if I say, yeah, let's file you a trademark, let's get the application in, that, like I've just explained, has totally different meaning depending on where we are. So, making sure that we're explaining those ramifications of each step of the process has been something very helpful to our non US based clients as they try to enter the US market. And we try to make that process as seamless as possible. So, on top of being virtual, we do everything through e-signature, video calls. So you don't have to see us in person if you don't want to. You don't have to pay for the flight ticket for me to come out to Dubai if you don't want to. And those used to add a lot of cost for more traditional businesses because that used to be the requirement, right? The lawyer, the head lawyer would have to come out and have the meeting. And so we've been able to offer these things at much more reasonable prices by American standards because we have adopted all of these technical aspects, which also allow us to, you know, understand a bit more where startups are coming from because law firms, it's an old industry. It's an industry that has not changed much or well and generally doesn't like much change. And that generally doesn't vibe well with startups who are literally trying to shake up the economy as we know it, or services as we know it, or a certain product as we know it. So having a legal team that understands, and maybe not to the extent that you guys are doing it, because you guys are pretty awesome. I bow down to the startup guys. It's amazing stuff. But at least understands the framework that you're thinking of things from. Makes sure that we're getting a trademark application in for you that gets you the most value for a single application. Because look, funds are limited. Even in a startup that's got, an angel investor behind it, or you're on your seed, whatever funding, money has to be used in the right way. And the reality is, when you're investing into marketing, when you're investing into development, legal should be thought of also as an investment, and making sure that the investment has the right ROI coming back on it is going to be crucial for any startup founder. So we try to keep all of that in mind when we're working with our people.
So you were talking about like the investment, the ROI. How what is like the before and after event and your kind of desired outcome for a startup, that instead of say that you would take the risk and go in, and then if you would have everything in the products that would stand still when you get like a legal notice come to you, what would be the message to these kind of business owners and startups that this is maybe not the right way to go, but this is a
Yeah,
much smarter choice, choose lane A instead of lane B?
absolutely. So let's talk about what lane B looks like, and you ignore the trademark and we see what happens. So for those international businesses that are trying to enter the US, we already talked about, right? Like if you've put people in town, people on the ground, you've hired space, all of that kind of has to freeze. If you're talking physical products and you suddenly get a cease and desist letter that your mark is infringing on somebody else's that's already registered or already existing in the United States, doesn't even have to be registered, right? Your stuff stops at the border. Customs freezes everything. All the packaging that you have that has the brand name on it all has to be redone. At minimum, the cheapest way to do this is generally putting stickers on it, but it depends on your brand design. You have to redesign all of this packaging. You have to redesign the website. You have to go into your payment processor and rename the byline that shows up on the credit card statement of your customers when they buy it, if that was one of the infringing trademarks that somebody else is coming after you for. Just the hours for even the cheapest person on your staff to go through and do all of this is going to add up to more than our legal fees for filing an application. So, that being said, that one's very simple. And that happens whether you're a non American client or an American based client. And then we get into like the intangible side of things. When you start looking at investors' expansion, I know investors that won't talk to startups. They won't talk to them unless there's an application in, at least, if not having the full registration. Registration right now in the United States is taking anywhere from 12 to 18 months. This is not a process that you can get done overnight like you can in most other countries. I mean, not overnight, but it's a lot faster. The American system's quite slow. So thinking of this as foundational stuff that will pay off in the future, even just in avoiding nonsense, Like, if you told me I could pay X amount of money to not have to deal with something that will cost me 5 times that amount on the best end today for the problem in a year and a half, yes, absolutely. And when you're talking about startups that are looking at exit as their primary goal, right? Exiting in 5 years, exiting in 10 years, whatever the case may be on their timeline. But that sale to another company, that acquisition, a lot of the times you'll see that acquisitions are happening for two reasons. One, because they have created a product and SOPs, right? And best practices that can be easily handed off because they're all documented. You already have the supply line set up. You already have your people set up, and they're buying that because they think they can put all of your product into their own supply line and distribution system and sell even more of it. That's why people buy product based startups. Why do people buy service based startups? SOP and the brand power, because they keep the brand, they buy the trademark. That's part of these acquisition agreements. And what we've seen time and time again is the largest exits, the largest payouts that founders are getting is because these systems are built and the trademark is specifically referenced in the purchase agreement when the exit happens. If you don't have the trademark to sell them, your buyer price just decreased dramatically. Also, go work with an SOP person and document all your stuff because it's me and your SOP person. We're the ones who create the sticker price when you're trying to do your exit. So you've got two sides of the coin there, right? Paying to prevent a very expensive, very painful, very annoying issue, and dramatically increasing the value of your company when you decide it's time to exit.
That makes so much sense, and it's definitely I would choose option A. Was it B?
It's
Okay.
easier. It's much easier.
Yeah, for sure. So this is a podcast about AI. How are you using AI in your work?
How am I using AI in our work? A lot of our marketing material is being created parsing information from the internet. It has cut down personally on my time and my team's time on being able to keep up with everything that's happening. Within AI, within law, things tend to move fairly slowly, but it's still like it's long documents. It's a lot to go through. Within AI, things are moving so quickly that just keeping up on the day-to-day updates is tough. In the past week, Sora AI wound up on the app market, skyrocketed as like the most downloaded thing, even though it's still invite only and is already losing steam because they have trademark issues, by the way. They didn't talk to
Really?
anybody like
Okay. Yeah, of
yeah. Well, all the videos that Sora AI is creating, at least initially, were using trademarked character after trademarked character,
course. Yeah.
using other people's likeness. This was all intellectual property issues that I don't know if they didn't talk to an intellectual property lawyer or they're trying very specifically to push the bounds of what intellectual property means and who can use it and how without paying. That's going to create legal battles for years to come. Years to come. And this is what they managed to do, create and break within a week. So we've been using AI to keep track of things like this because just keeping track of the massive amount of changes and information out there has been tough. And this has really helped us be better lawyers to our clients, be better marketers, be better explainers of what it is that we do. And then we're having early discussions with a very large company about how we can use all of our own internal processes and SOPs to create, in the simplest terms, a bot that will do the first draft of the version that our trademark lawyers do when they first have a conversation with a client.
Wow, that's interesting.
It could be really cool. We'll see. There's a lot to research into that, a lot of privacy issues, a lot of confidentiality issues. And a lot of, as any startup owner knows, a lot of iterations. But we're definitely looking into building our own internal systems on this. And also kind of waiting to launch these until we know that the use of AI at this level, at this scale, is not going to significantly contribute to environmental damages. The speed at which AI has become, and I won't say sustainable because definitely not sustainable yet, but less damaging on our environmental systems is amazing. And if it keeps up at this rate, then there is every reason to believe that it will be just as taxing, if not less taxing, than you running the AC in the summer in Brazil, which is where I am right now. And I will be turning on that AC after this podcast. But that's definitely something we try to be mindful of. And for now, our people are good. They're fine. But they're also excited about this. And it's something that we can pass on the benefit to clients. And to see startups in this space using this to dramatically change people's lives, I think we're looking at a world where humans will have more freedom and more ability to solve issues for themselves rather than being completely reliant on individual service providers. And that's something I hope we can contribute to.
That was kind of my next question is that how do you see AI in say 5 years or 10 years in the
Yeah.
legal field?
In the legal field specifically, like I said, we're an old industry. We move slow. We don't like change as an industry. As a firm, we try to reject all of that. But there are spaces in the legal world already where larger research companies are feeding the massive amounts of data that they've had, right? When we need to go search legal cases, when we need to go search laws across 3 different countries, there's a couple big names in the industry. They have already built out bots that you can engage with in a more natural way. When I was in law school, they had trained us, literally trained us how to search their databases because it was that complicated. So already it's making it easier for even lawyers to speak to our own tools in ways that we want to speak. So if we spend less time training how to use the tools and just using the tools, if you're being billed at an hourly rate by your lawyer, then theoretically you'll get a slightly smaller bill. That being said, the cost of the softwares are all going up because they're adding this framework. So I'm not sure how that's going to pan out right now. I do know in my circles, the law firm owners, the fellow law firm owners that I speak to, a lot of us are really, we operate almost exclusively on flat fee services. We don't charge by the hour. And a lot of other firms are trying to do the same thing because in what other industry do you get charged because it took longer to get the thing that you were trying to buy? Like, that's not your problem as a consumer. But somehow in legal it is, which is fascinating. So we're trying to move away from that, move really to value-based pricing, which I think AI will be helpful in doing that too, because we'll be able to more easily say, no, I don't have to tell you I'm going to guess how long this research is going to take me because I have tools that help me research much faster now. And I know how long drafting takes me. And I'm getting tools that help me draft faster. And I can see more examples from all over the world, the way things have been done in a bunch of other ways, so I can create a better solution for you. Right? I think we're getting more personalized legal documents, legal solutions, ideas that allow your lawyers to be more strategists, more counsel, rather than document pushers, which a lot of associates, a lot of our lower level lawyers have been in the past. And that's kind of how they learn, and it sucks. But I think we're moving away from that to allowing humans to do what it is that they excel at, which is creative problem solving, rather than, you know, working on the factory line and assembling, which is what legal could feel like at times. And I think that really reduced the value of what legal solutions were in people's eyes for a long time. So they're like, no, look, I just need an NDA. It's not a big deal. You're like, sure, if I copy and paste the template, but if I think about your business and I know the specifics of it and I know what's important to you, I can create one that's much more personalized to you because I now have the ability to use tech, use AI to crank out your baseline form. And then we can make sure this is a much stronger thing for you and your business and where it's at today, rather than copying the one that like Coca-Cola used, which has no application to your business whatsoever, right? And Coca-Cola has a really strong non-disclosure agreement, which is why I bring theirs up, because they're very protective of their stuff. But that doesn't mean it applies to your business. You are probably on a totally different business model. So allowing humans to be that thought process rather than, right, what do I need to make sure is in an NDA again? What is the clause that has to go in here to make it okay for the UAE? What's the clause that has to go in here to make it okay for Italy? What's the clause that has to go in here to make it okay for New York State? Good, they're all in. No, now I can just ask those questions they put in, and I get to spend time thinking, I need this to work in all of these places, not I just need an NDA, right? So I think that's going to dramatically help the legal industry provide better solutions, especially to smaller founders, right? You don't have an in-house team. You're not Uber. Half of your workforce is not lawyers, and it doesn't need to be, and that's amazing.
Absolutely love the customer centric approach you have in your law firm, and the fact that the flat fee instead of the billable hours, and taking AI and really looking into the future. Next question is, Mace, how do you see in 5 or 10 years? How do you see like the trademark field? You said that there's a lot of forms. Could this be done with AI or?
Yeah, the forms that we submit are actually, we have a software already that that transfers like our intake form into the application form with the US Patent and Trademark Office. So we're already at the point where, that automation of data transfer, it's already happening. What in trademark is still requiring, the lawyer's brain is the strategy, because in US trademark, you have to claim each industry, each category of things that you want to protect. What do I mean by that? I mean, Delta Airlines and Delta Plumbing, that makes a bunch of faucets and shower heads and things like this. They have the same company name. So, by the simplest explanation of trademark of you can't have two companies of the same name, that wouldn't be allowed to exist. What nobody continues on saying or hears is that you're not allowed to have two names that are confusingly similar to a customer, a potential customer, in the same space. Right? I don't think the airline is going to suddenly start making shower heads. I am not going to look at the shower head in the department store and say, I bet the airline is making those now. I don't have that confusion in my head. But when we file the applications, we have to say, I am taking this brand name for shower heads. I am taking this brand name for airline services. Where the strategy comes in on trademarks is A, starting with doing the big search in the United States and making sure there's not already somebody operating there, because all these fees are to the government to make the application are non-refundable. So we don't want to put in a trademark that could cost, it's $350 per category right now. People can spend thousands of dollars just on claiming the categories of stuff they want to protect. We don't want to throw that away if we don't know the name is like possibly going to go through. If we have a version of no, definitely not, this isn't going to work, we don't want to waste the money on that. So we have AI helping us, do that big search, but we still need an attorney to review it. It can give us some preliminary ideas, but these searches come back with like 4,000 results sometimes. So having the AI help us categorize those, so the attorney's spending time looking at the most relevant ones and then scanning quickly through the lesser relevant ones as it gets less and less relevant, that's very helpful. Having the attorney decide the categories based on what the company's already selling, what they want to sell in the soon to be time frame, that's still very much on the attorney side of having those thought processes of, right, they told me they wanted to expand into this in like 6 months. I bet we can probably put that on the same application if we do A, B, and C. So far, we haven't found already existing software that can walk through those kinds of processes. So it is already helping speed up the process. It is already helping people know their applications are more likely to go through, or at least give them the risk level, and then they can decide if they want to, try it or not. And, within not necessarily AI, but simple automations, creating reminders of, hey, it's time to tell the US government you're still using this brand, or they're going to cancel your trademark, because we have these things come up every couple of years. So those kind of things are already happening. As far as growth in that area, I don't see right now within the legal industry a lot of push to further optimize it at like a SaaS level. I don't see any SaaS companies coming around being like, yeah, we can analyze it for you, because this is still such a fact specific thing. And the problem with large language models right now is you can ask it a question. Overwhelmingly, they tell you what you want to hear. They always tell you you're right and wonderful and amazing. And if you don't know the right questions to ask, it's not going to give you the right information. As of today, we still don't know how to ask all those questions without overwhelming the user with questions that may not apply to them. And I know there's conditional logic that can apply to this, and there's startup people much more intelligent than I am on this stuff that can guide you on like how to do that. And hey guys, if you want to partner, I'll be your legal counsel in setting this up. Let me know. Technically, I am not the person that can set that up though on the inside, on the operation bit. And I don't see a lot of progress on it right now. But this is also not the most urgent thing within legal that software operators would be looking at to optimize. The first big use of this was in something within the legal industry called document review, which is basically when there's a giant case, and you've all seen the TV shows, right? They walk into the room and it's full of boxes, full of thousands and thousands and thousands of papers, because the other side delivered the discovery, and they're like, we're going to drown you in paperwork. And everyone's like, oh my God, we have to go through all of this. This happens on like a secured drive now. And then you feed it into some kind of LLM and ask questions instead of somebody going through every paper. This is still problematic because even the lawyers don't know what they're looking for necessarily. until they get some ideas by looking at some other ones. But that was kind of one of the first places where we saw LLMs start applying, and then AI in general, because they'll start hanging up the specific documents that they're flagging for attorneys to look at. I think we will continue on this path for sure. We're not there in trademark yet because it's a little harder to do. And there's not, for a lot of companies, there's not so much data or volume, which is really where AI succeeds, right? I'm curious. I'm very curious. It's the whole industry is fast moving, and within legal, you're trying to put a very fast moving industry on top of a very slow moving industry, and the fight seems to be real.
Definitely. Trademark and intellectual property. You have, well, there's this famous case on Bart's versus Anthropic that just recently got settled. That was a very interesting kind of what would see what would happen. But a lot of large language models are using other people's trademarks and intellectual property in ways that they maybe shouldn't.
Yeah.
What's your view on this, and kind of how do you see this turning out in the next 5 years?
Yeah. So before we get to my view on this, I think it's very important for our listeners to understand that when we're talking about intellectual property, we've got three legs of intellectual property. We've got patents, which generally are designed to protect inventions, novel ways of doing things, processes that don't exist anywhere else, the way that you make that particular ingredient in something that nobody else knows how to make, right? These kind of things. We're talking like the inventors of the world. These are the guys that work over in the patent space. That is not my space. For a lot of folks, that's not their space either. For a lot of business owners, what we really need to be talking about is copyright and trademark. And these are two different things that get used quite interchangeably in the non legal sphere. But it's important to understand before we start talking about the Anthropic ruling, the difference between the two. The simplest way, very simplest way to explain this is copyright protects content, anything you can watch, listen to, read, engage with. Trademark protects brand identity. So I bought this t-shirt because I know Nike made it. I watched this movie because I know it came from Disney. And Disney putting their logo on Disney Plus when you watch it. I was thinking back in the days when you bought VHS or DVDs and you saw the big Disney logo, you're like, oh, that's Disney, buy it. You didn't even care what it said, right? And there's people that are like this when we start talking about phones, right? There's a big divide in the world between the iPhone users and, well, everybody else. And iPhone people will buy the new phone just because it's Apple, right? Like, no, I'm buying that. By the way, Apple and iPhone, both trademarks. iPhone specific to the phone, Apple specific to the larger tech company. And they both get to exist because they don't inherently describe what it is that they're selling. And Apple does not describe tech. We all inherently think of it now with tech. And they actually went so crazy at one point, they tried to sue some like apple farmers in Switzerland. Like, no, but they're actually apple farmers. Shut up and sit down. The EU was like, that's ridiculous. You need calm down, Americans. That was fascinating. So when we're talking about the Anthropic lawsuit, very specifically what we're talking about is, this chatbot that was fed a massive amount of material, a large part of it copyrighted by the authors who had written it, of course, right? They put their time and effort into creating these materials. And what they had done over at Anthropic is they had bought some materials legally, and then they had just taken a lot of copyrighted material. And they fed all of this in to create the LLM. So why is Claude the better one at writing like human sounding marketing material? Because they took it off of a bunch of actual human writing. Should they get to benefit from that? Right. And so these are the questions that came up in this case. How much should Anthropic be able to benefit from it? In the material that they bought, because they bought it, do they have the right to put it into their own LLM? For the material that they didn't buy, because they were able to access it, should they be able to use that too? The question on the material they didn't buy, the copyrighted material they didn't buy, was much clearer. Obviously not. Obviously not. For the stuff that they did buy legally, they didn't really answer the question because they settled. What happened is Anthropic said, we don't like this question. We don't actually want an answer for it. We're going to give you, I think it was like $150 million, the settlement. And that's supposed to be divided between all the pirated material, all the pirated authors. Yeah, I think it was about 150 million. Between 7 million books. 7 million books. So what happened is there became this discussion of, if I read a book and then I take the material and I go write a blog article on it, have I materially change that material where I am now the author. Because this is really what came down to the core of the Anthropic case, and this is going to be a big discussion for a while. And it's been a discussion before of what does authorship mean? Because authorship is the crucial point to having a copyright in something that you've created, in that painting, in that song, in that blog post, in that whatever. And we've been here before. There was a monkey. I don't know if anybody remembers this. There was a monkey that grabbed some photographer's camera. The monkey's name was Naruto. Yeah. And he took a selfie. And this selfie went famous around the world. And the photographer licensed it, I think, to National Geographic or a bunch of other places so they could use it in their magazines. And he made a bunch of money off it. And what happened? PETA, actually the Animal Protection Organization, sued the photographer saying that the monkey
No.
owned photo. Because who took the photo? The monkey pressed the button. The monkey's in the photo. But the photographer set up the camera and created the situation that would encourage this monkey to press a button on a camera that he had never seen before. There were large discussions back then, and this is an old case. This is a while ago. There were large discussions back then of, what is ownership? What does it mean to take some inspiration and materially change it into something else so that it's no longer just inspiration, so that now you are the author, you are the creator. We're having those same questions now about Anthropic. And Anthropic basically said, yeah, we don't want to answer those questions. Here's some money. Let somebody else deal with it, which is a long way to say that these battles are going to keep continuing. Every time we have a new tech, every time we have a new situation that we haven't been exposed to yet, and who should benefit from that. It's going to take time to figure it out and to figure out what that means. And the LLMs have been moving so fast in the consumer space. I know that they've been going for a while, in the business space, privately, the development of this has been going on. But for consumers, this is new. This is radicalizing how they view access to information and what is ownership. And those are questions that just, I think, as a society, we are going to have to evaluate for probably some years to come, and maybe on a more ethical and moral level, hoping that our legislators, our lawmakers are really evaluating who deserves to benefit from the exploitation of this material. And exploitation, not in a bad way, but like you write a manuscript and you turn it into a book. Is it you, or is it the publisher, or is it your editor? Who gets to make money off of this? I mean, that's the question at the end of the day. That's always the question in business, right? Who's making money off of this thing? And those are just tough questions we'll have to grapple with.
So, say Anthropic, I write an amazing book that Anthropic then edits. Does Anthropic have the right to basically say that's their book, or how does it work? Like, or can a robot be at the moment, or an AI bot? Can they have ownership of anything?
Oh, that's the great question. Can a robot, can an AI, can an LLM own something? As of right now, the way that both the recent Italian law and the American courts have currently held it, and look, this could change next week because the space is moving fast. The monkey doesn't get to own the picture, and the robot doesn't get to own your stuff. If a human significantly engaged with and created the thing, what happens, right? The photographer put up the camera. The monkey didn't go buy a camera and take a selfie of himself, right? You engaged with the AI. You did not go in and say, write me a children's book about penguins, and then sell that directly, right? You didn't make any changes to it. Okay, well then Anthropic probably owns it. Yeah. But if you go in, you say, make me a children's book about penguins. And, one penguin should be from this side of town and the other penguin should be from this side of town. And here's the storyline that I want to tell. And it spits out a first draft. And then you're like, actually, I think we should add in this element, and they should have a friend who's a bear, and they should run across somebody who's a pilot, and this and this and this. And you keep engaging with it, then that's yours because you have done something to use this as a tool rather than allowing the tool to create for you. As of today, that's where we're at. Make sure you're using it as a tool, not as a production of like a complete production. And then you're the owner. But if you're just using it to spit out stuff, yeah, no, it's you don't own it.
How does it work in terms of liability? Who's liable? Say I build a product that's supposed to be do this and this. How does it? Or I build a robot that's supposed to be a mechanic, and then it messes up the car. At the moment, how does it? Or I create a bot that then gives out false answers. Where does the liability issue goes? Is it the cloud
It's the
version that it
company.
runs on, or is it
It's the company. It's your job. You made it. It's your liability. And it's been that way forever, right? It doesn't matter what we're making. If we go to a factory in China or Vietnam and we're like, hey, can you make this product that I want to sell all over the world? As long as the manufacturer, the tool, created what you told them to, and nothing is like on the surface a problem when you look at it to bring it and sell it to your own people. The liability has always been on the business selling, right? If you're the creator, it's you. And in certain industries, we have to be very careful about that, right? There's very specific regulations around legal advice, medical advice, weight loss advice, in no, I think almost every country in the world. These three things, financial advice, right? These three things are highly regulated. So if you're operating in any of those industries, you need to go check a whole lot of regulations before you start doing anything. And even the AIs, they know this, right? The LLMs, if you ask it like financial questions, it's like, I'm not a CPA. You should probably go talk to a financial professional. You're like, hey, I've got a rash on my knee. It's like, I am not a medical professional, but this is what I found. And what you'll notice is anytime you talk to a lawyer, and especially if you hear us on stuff like this, what you'll also hear us say is, well, I can't tell you what to do, but I can tell you what the trend is, or I can tell you what I would do. This is not advice specific to your situation. This is generally what I've seen as an educational, informational bit. Is this everything you need to know? Have I asked all the questions that I need to ask to give you real information that you can depend on and like take as advice? No, absolutely not. But here's all my disclaimers. So they're full of
Samantha,
disclaimers right now. Responsibility's on you. Yeah.
Samantha, thank you so much for this discussion. This was super insightful, and thank you so much for being on the podcast.
Thank you. I really appreciate it. If this was helpful and you have any other questions about like whether a trademark works for you or anything, we've got a trademark quiz over on our website that walks people through this. It is not AI. It is automations though. And it helps you figure out, if this is something you need to be thinking about as a startup owner, as a business owner in the early days when it's actually affordable and cheaper. So yeah, please go check that out. And if you've got any other questions, just send me a DM. We're pretty active on Instagram and TikTok.